Hello, everyone, and welcome to today's webinar, 6 Critical Legal Documents to Consider by Age 55. My name is Carol Misso. I'm the Chief Operating Officer of Cunningham Legal, and I'll be your moderator for today. I'm pleased to introduce today's speaker. It's Jim Cunningham. So Jim is the CEO of Cunningham Legal. We're an estate planning and trust administration law firm with 9 offices around California. And he's been presenting in front of live audiences for probably the last 20 years. So Jim's also a published author and is currently working on his second book. Today, he's going to share the 6 critical documents you should have or consider having by age 55. So keep it in mind, we say 55, but it could be in your 40s or your 70s. Really, everyone kind of needs a plan. So it's really all about taking action today to get your affairs in order. I'd like to kick things off by welcoming our CEO, Jim Cunningham. Jim, over to you.
Well, Carol, thank you for that introduction. Today, we're going to talk about some documents to consider in estate planning, and the reason we choose age 55 is for a variety of reasons, and we'll get into those. But people who are 55 often have older parents, so parents who are living, but they're getting a bit older in life. And also at age 55, many people with children, their children are just beginning their lives, frankly, as adults and graduating college, hopefully, or high school, or just kind of starting out with their families. Planning also gets harder with age, and I'll elaborate on that. But, when you're young, I think back to when my wife and I first started having children, our children hadn't yet gone through puberty. They hadn't become adults. And so a lot of planning issues arise as children age, and then we'll talk a little bit about that. Health, I would say, plays a larger and larger role, certainly as people age. And for some people at 55, health unfortunately can be an issue, positive and negative, but it does play a big role. And then we'll also talk about how to get started, and we'll round it out with a Q&A. Now, before we get started, I do need to let you know that I'm a lawyer and I'm licensed in California, and I'm speaking. And just because I'm a lawyer and just because I'm talking doesn't mean that this is legal advice. So it's very important to understand that this is information only. Don't take what we say here or what I say here and run off and go do something relying on this information, because legal advice is one-on-one with a lawyer, where the lawyer learns your individual situation. So please keep that in mind. So why age 55? I turned 50 this year, which was kind of a watershed. I think for everyone who turns 50, it's kind of a watershed age. And what I've noticed is, life kind of evolves, and my children, my wife and I have 3 children. They're all no longer teens, or our youngest just turned 20, and they're starting their lives, and it's very exciting. And it made my wife and I reconsider how our estate plan was written, so our living trust. And so that's something that's really top of mind for us. And also I include health. My wife, her parents are in their late 80s and require a lot of assistance. And so many of you listening, you might be that older parent, but you might also be the old child, if you will, right, with elderly parents. And for some people, that can be a tremendous emotional ride, certainly financial, we'll cover that, but it's kind of a big deal caring for an aging parent. So that's really why we choose 55. So what we're looking at is not only you, if you're in around age 55, but also your parents and your children, if you have living parents who are living, and children. Also at 55, retirement is near, and as they say, your runway's getting shorter. So these are all things that, at age 55, what we see is people really start thinking about it maybe for the first time, but also start rethinking about estate planning. Now, unfortunately, many adults have not done basic estate planning. So 58% of Americans don't have a will or an estate plan. And we'll talk about what I mean by an estate plan, but they don't have a will or a living trust. And 64%, it's even higher, 64% of Americans with children under the age of 18 have no end-of-life plan in place, no estate plan. And that's very important, as you know, if you have a child who's under 18, where that child lives, if something happens to you, if you have a grandchild who's under 18, where they live and who's in charge of whatever their inheritance is. Very, very important question. And only 37% of Americans have an advanced health care directive, and we'll cover what that means.
Okay, great. So Jim, I have the first poll for our audience right now. So just one quick interruption. It's helpful for us to understand a little bit about our audience. So if you can tell us a little bit about your current marital status and what age range do you fall into? And you'll see your options there. Just click on it, and it will register. Okay. Good to see. Thanks for doing it. That gives us a good idea. Thanks, Jim. Go ahead.
True story, Prince, the artist formerly known as Prince, I guess is his official name. He passed away in 2016. His estate still isn't settled. He left no will. I mean, this is really, Carol, I can't believe that a person as significant in culture in the music industry as Prince has been, for the last 25 years, that he would die without a will. But you know what? He's a brilliant musician, brilliant artist, died without a will. Unbelievable, but happens a lot. Estate planning, I want to make clear, estate planning, even though we're talking about documents, is not documents. And I want you to think of estate planning as kind of like going to the doctor. Why do we go to the doctor? Sometimes we get a health checkup, sometimes we get a health issue. The documents is really the prescription. So you can think of the estate planning as the doctor's role and the documents as the pharmacist's role. But it's the lawyer who does both of these. But the most critical part of this, folks, this is very important to understand. It's the counseling that you get from an expert lawyer. It's not the document itself, because if the document's inappropriate, it can actually do more harm than good. So let's start number one. And again, these are documents to consider. A revocable trust. What is a trust? You can think of a trust as a bucket, right? So we have a picture of a bucket here. I like to think of it as a super will. Now, what do I mean by that? Well, a will, when you pass away, a will says who gets your property when you pass away. A living trust also does that. But what makes the living trust a super will is that where a will requires probate, and we've all heard that that's bad, it's expensive, time delays, a living trust does not. And a living trust provides a mechanism to manage your assets, not only when you pass away, but also during incapacity. And we'll talk about incapacity. It actually happens more frequently, almost as frequently as death. You can protect a loved one with special needs using a living trust, special terms. And also, not all living trusts do this, but many expert lawyers, if you meet with an expert attorney, whether it's with someone with our firm or another expert lawyer, that lawyer is going to ask you, or should ask you, do you want to protect your child's inheritance from divorce? Now, I have yet to meet with a client who does not want to protect their child's inheritance from divorce. Everyone says, well, yeah, I want the inheritance protected. Yeah, that makes sense. Half of all marriages, more or less, end up in divorce. So it's a real threat. And a revocable living trust can have some positive tax implications when people pass away. And unfortunately, with older estate plans, older living trusts, some negative tax consequences. And the negative tax consequences are a result in the change of the law, very recent changes, especially in 2017. So if you have a living trust and you haven't looked at this thing in a year or two, I would highly recommend that you dust it off and take a look at it. Second document, last will and testament. Now I put the term last will and testament in there. It means the same thing, but testament is the French derivative and will is the Germanic derivative, but it really means the same thing. It's the last document you sign that's your will. Now, lawyers are hesitant to say everyone should do this or everyone should do that, but I would say this is the one instance where pretty much everyone should have a will, because we should designate the person to take care of our affairs when we pass away. If you have minor children, many times the designation of a guardian will appear in the last will. Now, it's very important to understand, if you have minor children, or if you have children who have minor children, they're your grandchildren, the person you name as guardian is not necessarily going to be appointed as guardian. There's a process that happens after somebody passes away. So So if the parents pass away, there's a court procedure. The parents can nominate a guardian in the last will and testament, but it's the judge who appoints the guardian, and they do go through a background check. So it's very important. You're going to want to name someone who's responsible, financially responsible, and also, wouldn't, after a court investigation, the judge wouldn't say, oh, this is a terrible person to appoint. Now, some assets, even if you have a living trust, so people ask me, hey, Jim, I've got this living trust, and I also have this will. Well, that's actually called a pour-over will. And so what that means is whatever is in your name, if you have a bank account or a safe deposit box in your name, that will pours over into the trust. So think of a bucket as pouring over. So that's a will. Third document, durable power of attorney. Now, it is important to know what a durable power of attorney is and is not. A durable power of attorney, also known as a durable power of attorney for property management and personal affairs, designates a person called an agent. Now, in our office, Carol, we use the term agent. We don't use the term attorney in fact. Now, under California law, you can use both. The problem with using the term attorney in fact is it's very confusing for the client. They go, well, is my lawyer the agent or the attorney? I don't understand. So we use the term agent just to make it simpler for our non-lawyer clients. Powers of attorney can give current authority or future authority. The future authority can be, if I create a power of attorney and I name Carol as my agent under the power of attorney, I can give her that authority immediately. And so for those of you with older parents, oftentimes that's a topic of discussion when your parents do estate planning. We might think about being a current. So my wife with her parents is a current agent under her parents' durable power of attorney because they need help. It can also be at a future date. So it could be when I get sick or incapacitated, or when I designate you, Carol, to serve as trustee. And so that would be on authorization. So what is a durable power of, who's it for, what's it for, what problem does it solve? A durable power of attorney is used in conjunction oftentimes with a revocable trust and handles all the things that are not in the trust. IRAs, 401ks, tax returns, that's a biggie. And it's also a properly crafted durable power of attorney with an expert elder law attorney can be very helpful in protecting an elder's assets and obtaining needs-based government benefits. Now, for example, if you run out of money and you go to a nursing home, the state's not just going to kick you out on the street. The taxpayers pay part of that. So that can be, the durable power of attorney can be helpful in that planning process.
Okay. Jim, before you move on, we just had a quick question. Sounds like George has some issues. He says, how can I revoke my power of attorney? Because it's, is that something that's simple for people to do, Jim?
Well, in law, as they say, it's not as simple as it seems. Yes, you can. Oh, the other thing that happens is when you die, that durable power of attorney goes away. So it's very important to understand. The durable power of attorney ends. So if I give you that power, Carol, and I die, it ends. It doesn't survive me. How do you revoke a power of attorney? Well, you sign a new power of attorney oftentimes, or you sign a document that revokes a prior power of attorney. But under California law, you have to communicate that revocation to the prior agent under the prior power of attorney. Otherwise, they can still act under the power of attorney. So there's a communication element. Very good question. This is really kind of sad. There's an 80% probability of disability prior to death. Now, disability is not incapacity, right? So you can be disabled, but not incapacitated. So I can have a stroke and not, lose some bodily functions, but I could have cognitive ability. I would be disabled, but not incapacitated. If I have advanced Alzheimer's, I'm, disabled and mentally incapacitated as well. But there's an 80% probability. Death obviously is 100% probability, and we're, part of this is talking about that. But if something is an 80% probability, absolutely, you need to be thinking about it and have a game plan, folks. I mean, you need to have a plan in place about the people who love you. And really, if you think about it, the people that make these decisions oftentimes are the people that really do care about you. So they care about you, make it easier on them with a good plan. $9,337 a month is the average cost for long-term care in California. Now, what this figure represents is they look at nursing homes, skilled nursing care facilities across the state of California. So you might take one in Los Angeles, one in San Francisco, another one in Barstow, another one in Fresno. So those areas have different costs associated with them. Some are higher, some are lower, but the average in California is $9,300 a month. It's a lot of money, folks. This is not $2,000 a month or $1,000 a month. It's a big number, and it does require some mindfulness and some planning. So the fourth document is an Advanced Healthcare Directive. Now, the title, I chose this title. There are variants on this title. Some of you might see a durable power of attorney for healthcare. So that would be a similar document to this. Sometimes healthcare is 2 words. I just chose to make it 1 word here, so it's a stylistic thing, but those are all going to be covering the same things that we're going to talk about in this slide. So in its essence, an Advanced Healthcare Directive designates a person to make healthcare decisions for you when you can't, right? Now, a while ago, federal legislation was passed called HIPAA, and the state language, the California enabling language, so HIPAA was federal language, and then each state passes their own rules, is the Confidential Medical Information Act. That's the state implementation. So what these cover, this is kind of like a Fort Knox on medical information, and I think we've all experienced this. You go to a healthcare provider and they say, Carol, please sign this document acknowledging that we're not going to share your healthcare information with anyone else without your permission. And when I've signed those, I think, well, of course you won't. But they tell you this, and I'm not quite sure the logic behind that, but they tell you that. So if I want to access another person's information, and this actually happened to me years and years ago when our son, who's now 23, when he was about 3, so 20 years ago, my wife pulled her back, picking him up or doing something, and got an MRI and then was getting some treatment. And I went down to the medical provider and I asked to get a copy of her MRI. And they said, well, you're not Lori, you're Jim. We're not going to give it to you. And I was like, oh, duh, I'm a lawyer. I should know this stuff. So I had to go back and get the HIPAA authorization, right? It's very important. The HIPAA and the Confidential Medical Information Act, the documents give someone else permission to access your own medical records. And this is very, very important. Also, under California law, a lot of people don't know this. A lot of healthcare providers don't know this. California Civil Code Section 56 mandates that the HIPAA authorization be in 14-point font. 14-point font. So, if you pull out your Microsoft Word and you start typing, a lot of times that's 12-point font. So 14 is a little bit bigger. Very important to have current HIPAA authorization because the laws do change from time to time on this. So I would say this is something to think about. And you can also provide for organ donation and, very importantly, disposition of remains. That can be a hot topic in a family. Do we bury mom or do we cremate mom? And who gets her ashes? And sometimes the last memories are the lasting memories. So sometimes the conflict that happens when someone passes away is what people talk about when they don't get together for Thanksgiving, right? So one of the points of doing planning is so that your loved ones will want to get together for Thanksgiving in future years. And sometimes, unfortunately, that doesn't always happen. So we talked a little bit about the HIPAA authorization. What's the difference and why do I separate these out? Well, the people that actually make the healthcare decisions for you may not be the same people that need access to your medical information. Now, for example, if a client has a son and a daughter as involved in taking care of mom, the son might be the trustee or the agent under the power of attorney, but the daughter might be the healthcare decision maker. Well, the son might need access to mom's medical records to help mom out as trustee or as an agent under a durable power of attorney. He may need access to medical records, but mom doesn't want the son necessarily making the decisions, but would want the daughter. So that's why we split that out. So many times the person who's handling your personal affairs isn't necessarily making decisions for you. And so that's why we separate those out. And again, The HIPAA authorization has to be in 14-point font in California, and that's under the Confidential Medical Information Act. So we have a funny cartoon here. A little comedic levity. Kind of reminds me of my dad watching news all the time. But anyway, well, let's finish up with the living will. So I have a picture here of my grandmother who is holding my father. And that's a long, long time ago. I would say that's during World War II. So a long time ago. A living will is a permission slip of sorts that my grandmother did not have when she was in the hospital. So about 20 years ago, my grandmother had a heart attack at home, and my grandfather called 911, and so the paramedics come out. And what do the paramedics do when they get to the house? They get out the paddles and they start reviving and intubated my grandmother, Peggy is her name, and took her to the hospital. Well, she had been without oxygen for quite a while, and they determined that that her cognitive function, because she had not had sufficient oxygen, was really diminished, and frankly, it was kind of time to let her go. My dad's a retired lawyer, and he was practicing at the time. I was a lawyer at the time. My grandmother did not have an estate plan, right? This is like the cobblers. I'm sort of I'm bearing my soul here. The cobblers, you know, kids and grandkids had no shoes, so to speak. So here's the problem. My father never talked to my grandmother about what happens if you reach that point where we need to pull the plug. My dad has two older brothers that are the sons of my grandmother. They never talked to grandma. And I was talking to my dad about a year ago. Bear in mind, this is almost 20 years after he was the one who made the decision after about a week to pull the plug on grandma. He says to me, you know, Jim, I don't know if I did the right thing. I never talked to her. So this has been gnawing on him for 20 years, right? So in counseling clients, very important to think about the legacy, your lasting legacy. And I think unfortunately, part of my grandmother's lasting legacy is there was never that conversation. There was never that permission slip. So a living will solves the problem. And by the way, parents out there, if you try and talk to your kids about pulling the plug, what are your kids going to say? They're going to say, Mom, what are you talking about? You know, if you talk about it, it'll happen. So consider a living will. You can not have a living will. You can say, hey, keep me going as long as possible. But most people say, hey, if it's my time, let me go. But it's that permission slip. I will distinguish this from a post. So a living will is a medical, or living will is a legal document. A post is a physician's order for life-sustaining treatment, is a medical order. And so you have a lot of choices, and this is that sort of hot pink form, if you will. And many times, these are given to elders when they go into an assisted living or skilled nursing setting. Basically, it says, ask the question, hey, if you're choking on a peanut, do you want us to give you the Heimlich maneuver or not? Do you want us to, perform these things in an emergency situation? So a post is not a living will. A post is not an advanced healthcare directive. You really do need to read that very carefully because that has to do with medical orders and not legal documents.
Okay, so Jim, now's a good time to interrupt you. So we have a question from Linda. Good timing because we've just finished through there. And she asks, well, I guess her statement is similar to many of ours where we say, okay, she has a few of these documents instead of all of them. And is that okay? I think that's, as we all look back on what we have, I mean, I don't know if there's a way to prioritize them or think about, how we go about getting all of them if we don't.
I would say that typically, certainly for the clients in our firm, most of our clients have all of these. And there's a little bit of maybe bias. If I'll put this in air quotes, you don't need a living trust if you don't have much in the way of assets, and the thresholds, depending on the assets, it's either if you have real estate or not. So if you have real estate in California, you should start thinking about a living trust. Well, if you don't have real estate and you have less than 150,000 in the bank or 150,000 in assets, you might not need a living trust, okay? But the rest of these documents, if all you have is the Advanced Healthcare Directive, well, it's good that you have that. But if you don't have a durable power of attorney, how are people going to care for you? if you become incapacitated? The answer, folks, is if all you have is an advanced healthcare directive and you get sick, the people that care about you are going to have to go to court and start what's called a conservatorship. And every lawyer I talk to says, hey, a conservatorship is at least about $10,000 to get started. And that's not all attorney's fees. It's a few $1,000s in court costs. So very important to invest in a quality estate plan, frankly, that suits your needs. So.
Okay.
Jimi Hendrix, another one, died without a will in 1970. His family fought for 30 years and settled in 2015. And Jimi Hendrix occupied the same flat as Handel, I believe, the 18th century musician. Kind of interesting little factoid in Notting Hill. So consider taking action. I wrote a book, Savvy Estate Planning, What You Need to Know Before You Choose the Right Lawyer. I will tell you, estate planning is worth doing. If anything is worth doing, it's worth doing right. Get an expert lawyer. This is an area of the law that a generalist should avoid because there are too many gotchas. And what is an expert? Well, I heard this definition, Carol, a while back. An expert knows what to pay attention to and what to ignore. But you do need an expert, not just any attorney, but you need an expert attorney so they know what to pay attention to in your situation. And really, it's about protecting yourself and your loved ones. 80% probability of incapacity, and last time I checked, 100% probability of death. So you got to plan for this stuff. And frankly, it provides peace of mind. And that's, I think, the big takeaway is when you do an estate plan, it does not mean you're going to die. And some people say, well, I don't want to do a will. It means I'll die. Well, that doesn't even make sense. But it provides you peace of mind knowing that it's set up.
If anybody, I know you are all listening, if you have any other questions to submit, just use the question pane on the right-hand side of your screen. I believe it's the right-hand side, and we will try to get to all of your questions. So, all right, Jim, we've got a first one from Jessica, and she's asking, okay, I hear everyone is getting a living trust, and is that what most people do?
Well, most of our clients do, and very few of our clients end up with a will-based plan. And that's in California. The reason is in California, if you have assets more than $150,000 or real estate, when you pass away, you've got to go through probate. And the probate fees are very high. They run about 5% of the value of the total value of your estate without regard to any liability. So if you have a house that's $1 million and a $900,000 mortgage, the probate fees are about $50,000. They're not based on the equity, they're based on the total value. So for that one big reason, many people choose to do a living trust. Also, is privacy. So a will is a public record, is a public document, and a living trust remains private. So those are the two big reasons.
Okay. So Martha has a pretty direct type question. She's saying, what do I do with my advanced healthcare directive once it's filled out?
Well, you want to get a copy and take it to your primary physician, so your primary care provider. You want to make sure that that advanced healthcare directive is in your chart, for lack of a better term, and it's available. If it's in your chart with your primary healthcare provider, then it'll be available for any other treating physician. It's very important. If you change it, you got to update it and send a copy out to your healthcare provider for an updated copy.
Okay. Let's see. We have one from Beck, and Beck wants to know, what is the difference between a power of attorney and a conservatorship?
A power of attorney is a legal document that the principal, you, right? You sign a power of attorney and you name somebody else. I name Carol as my agent. I'm the principal. I sign a document. A conservatorship is where I don't do that. And Carol, you go to court to get a conservatorship over me. It's a court proceeding. So a conservatorship is a court proceeding. A durable power of attorney is a document.
Perfect. Okay. We have a question from Xavier. Xavier wants to know, so what if I don't want to appoint an agent? I guess back to one of our earlier points, or don't even have one to appoint?
Oh, yeah. So people who don't have a trusted person that they can name to make financial decisions for them if they get sick, or your executor or your successor trustee, that's the person who after you pass away becomes trustee of your living trust and distributes all the assets. You have a couple of choices. One is you can name a private professional fiduciary, and that's a private professional fiduciary is regulated by the state of California, and they're bonded and they're professionals, and it's their business to serve as agents under durable powers of attorney and make healthcare decisions for people and be successor trustees and executors. And if you don't want to go that route, you can also use a trust company or a trust bank. And so those are institutions that can serve. So those would be your two options.
Excellent. Okay. Jerome, thanks for clarifying that. The revocable trust and the irrevocable trust that is created from the Jim, these words, these revocable trust and death, are both of those together considered the living trust?
Yeah, so this is a great question. While you are alive and while you're living, your living trust is general, and again, it's a general statement, is a revocable trust, meaning you can amend it, you can change it, you can revoke it. Once you die, it becomes irrevocable. You can't change it, you can't amend it, and you can't revoke it. The analogy I would use is a caterpillar becoming a butterfly. So your trust goes through the same metamorphosis. So while you're alive, your living trust is the caterpillar. And then when you die, it becomes a butterfly. It becomes something totally different. And so while you're alive, it's a trust that's used for your benefit. And when you pass away, you can't keep that stuff when you die. You can't take it with you, right? It goes to other people in an irrevocable trust.
Got it. I think that makes sense. All right. We have one from Francis. And again, I think people are still searching for some clarification on these, the documents Francis asks. So I already have a will and a power of attorney. Do I still need a living trust and a healthcare agent?
Yeah. So as I understand this, you have a will and a durable power of attorney. You should consider having an advanced healthcare directive where you name an individual to make healthcare decisions for you when you're unable to make them. If you don't have that, in order to make those decisions, the people that care about you are going to have to go to court and get a conservatorship. Still $10,000, right? At least that's to start to get a conservatorship. We
do have a number of upcoming webinars. I think these are great information sources for us, and Jim loves doing them. So please check our website at www.cunninghamlegal.com. On behalf of Cunningham Legal, thanks for joining us today.